In this video, I want to briefly talk about proximate cause and how you can better explain it to a jury, help them to see and understand it better to improve your chances and your client's chances of winning at trial. In my experience, I feel that proximate cause is the most common reason that we lose at trial. I mean, that's setting aside all the other different psychological and personality issues and surprises that can happen from trial. But from a straight negligence, causation, and damages perspective, it's that causation, that bridge between the negligence and the damages where we lose most of our cases. I would even go on to say that in many of those cases where we don't get a finding of negligence, it still has to do with causation, that the jury either didn't totally grasp how legal proximate cause works, which is very understandable, as you'll see in a moment, or they just didn't think that the conduct that you focused on the defendant was the cause in question. So, as is always critically important when we try a case, we have to do our best to put ourselves in the shoes of the jury and imagine what it's like to be a juror. And imagine you've gone through this whole trial, and at the end, you read this 30 to 40-minute recitation of dense law about how the case is to be decided and judged by them. And there's this section that gets read to them about proximate cause, which in and of itself is just like, what is that? And they get read something like this. I'm from the state of Pennsylvania, but I know that the instruction is very similar in most states. So after a week of trial or 2 weeks of trial and all this different evidence, they hear something like this. In order for the plaintiff to recover in this case, the defendant's negligent conduct must have been a factual cause in bringing about harm. Conduct is a factual cause of harm when the harm would not have occurred absent the conduct. To be a factual cause, the conduct must have been an actual, real factor in causing the harm, even if the result is unusual or unexpected. A factual cause cannot be an imaginary or fanciful factor having no connection or only an insignificant connection to the harm. To be a factual cause, the defendant's conduct need not be the only factual cause. The fact that some other causes concur with the negligence of the defendant in producing an injury does not relieve the defendant from liability as long as their own negligence is a factual cause of the injury. I mean, that is brutally dense and difficult to conceptualize, even for me as a lawyer that's been trying cases and handling cases for many, many years now. And then to expect a jury to get that right away and be able to process that and articulate it and think about it in the course of the evidence in the case is near impossible. And so you're not doing your job as a trial lawyer if you're not helping them really simply understand how proximate cause works. There has been an amazing analogy and explanation for proximate cause in the setting of injuries that's been around since the 1930s. And it was created by this gentleman, whose name is Herbert Heinrich. And Mr. Heinrich was an industrial engineer and considered to be the father of safety in regard to worksite accidents. And he dedicated his life to figuring out why worksite accidents happen and how to prevent them. And in explaining what happens inevitably in every scenario to lead to a worker getting injured or some terrible worksite incident, he came up with the analogy of dominoes. And as is applicable to just about every case, except for those situations where there are omissions, which I'll talk about a little bit later, he came up with this analogy that explains the situation perfectly and which a jury can understand. And you can imagine stacking dominoes up in a row. And the events start with the social environment, the circumstances in which whatever the events of your case happen occur. Okay, maybe there's an intersection with two cars approaching or one car stopped and another one coming up from behind. And then the next thing in the series of events that leads to what happened to your client is the fault of your defendant. and then they do something unsafe. Maybe they are texting while they're driving. They're not watching or keeping a safe lookout. Maybe they're traveling too fast for the circumstances. Maybe they blow a stop sign. They violate some rule of the road. And it's because of that unsafe act, the next domino hits over into the accident, causes the crash itself. And then that crash causes your client's initial injury. And that leads to, and then the dominoes go, and it shows how the chain of events led to what happened. But then the effective analogy that explains and visually shows and conceptualizes proximate cause is the removal of the unsafe act, the negligent act by the defendant. And when you remove that, certain things happen beforehand, but now they don't get to the point where the accident happens and the accident causes the injury. And so Heinrich came up with this concept that has now more recently been talked a lot about and written about, particularly by an attorney in New Jersey named Ed Capozzi, who wrote a book on trial guides called The Domino Theory, which I highly recommend you read. And there's actually some good videos where attorney Capozzi shows how he actually uses large domino pieces in court to make the point of proximate causation to the jury. And it's done very effectively, and I think you can use it really well. So some visuals that I'm happy to share with people that you can plug into a PowerPoint. If you email me, I will happily share these PowerPoint slides with you, are slides along this nature, where you demonstrate to the jury how proximate cause works, that there was this inciting event, and then that caused the incident and so on and so forth. And here's another way to think about it. And then you can put next to each of these dominoes describing each chain of events and how it gets to the point where it causes your particular client's injury. I mean, that is proximate cause. And then you can either physically create your own dominoes and pull the domino out so that it shows that but for, and that's where that but for concept comes from, but for that conduct, then nothing else happens afterward. The accident doesn't happen, the injuries don't happen, and so forth. Now, the one distinction that I want to talk about is for those of you that handle medical malpractice cases, but it's not just medical malpractice cases, it's situations where any negligence claim where there's an omission. Okay, so in most instances, it's the defendant did something, they acted negligently in some way, and then they brought about something occurring. But there's a whole series of cases, and it often happens in medical malpractice, where there's an omission. And so let's think about that for a second in a medical malpractice case. Imagine a situation where a patient has cancer, okay? Unbeknownst to them, they've developed a lung nodule that is cancer, and it's very treatable at that point in time. Now imagine they have an x-ray performed, a radiologist interprets the x-ray, but because the radiologist is having a bad day, is negligent, deviates from the standard of care, they miss it, and they say that the x-ray is normal. And so the patient is not diagnosed timely with their cancer, they do not get timely medical treatment, and their cancer is allowed to progress over a period of time until it becomes what's called metastatic. It's gotten everywhere, it's untreatable, and now the patient gets diagnosed, but now they can't be saved and they die. And a malpractice claim is brought that the doctor failed to make the correct and timely diagnosis. Now, you can imagine a scenario where the jury is asked, what was the cause of that person's death? And they could say it was their cancer, or they could go further back. It was the fact that they smoked, which then contributed to them developing cancer. And it was the cancer that killed them. It wasn't the doctor that came and killed them. And no matter how clear cut the fault of the doctor was, a jury could conclude that the doctor's omission, failure to make the diagnosis, was not the cause. And so we have to demonstrate to them why that omission was a proximate cause of the patient's injury. And you can do that with another domino concept as follows. So in this example, in this analogy, and again, you could physically do this with actual dominoes, which might be even more engaging to the jury, but this visual gets across. And you could show these fallen dominoes to the left of this hand were smoking. And the smoking then led to the lung cancer, and the lung cancer developed from a small few cells to a larger tumor, which then led to the patient to cough, which led to the patient to be prescribed to get the chest x-ray. But then you can show that had proper care been given rather than omitted, that none of the other bad things that happened to your client would have occurred. They would have gotten timely treatment. They wouldn't have developed metastatic. It wouldn't have spread, and they wouldn't have gone through all the misery trying to treat their metastatic cancer, and they wouldn't have died as soon as they did. So this is a very effective way to show how the omission was the cause, because then conversely, you can show the dominoes all falling and the hand above that never came down, so there was never proper medical care provided, and why that changed it, and why, but for the doctor's omission or the defendant's failure to do something, that all of these injuries occurred as a result. So as I mentioned, I'd be happy to share any of these slides with you, but I encourage you to really sit and think about proximate causation and how you're going to explain it to a jury. I think it should be talked about to some extent in opening statement so that the jury knows how to think about it and look out for it and point out to the jury that this is how proximate cause, and here's how to think about that and how the judge is going to explain this to you at the end of the case. And then at the end of the case, you can be even more argumentative and get into more details and show these visuals of all these different pieces that gets the point across. And by doing that, you're going to significantly increase the chance that the jury does not get sidetracked on what the cause was that led to the injury or death in question. I would also end by pointing out that Heinrich's concept of the domino theory is a great way to think about your cases in general. Oftentimes when we're evaluating cases, we jump on liability. Oh, there was a big mistake and there's big damages, we're good to go. But by really drilling down and doing sort of a root cause analysis as far as what really was the chain of events that led to this, and was it or did it have something to do with that clear-cut negligence that you found, is going to help you know whether this is a winning case or how difficult of a case it may prove to be, but also how to work up your discovery, how to work up your case the right way so you really bolster and make that bridge between fault, liability, and damages connect, so you increase your chances of a recovery for your client. I hope that helps. I hope to hear from some of you to share these slides with. Thanks for watching.